And we will have the opportunity at that time to also make our closing speech. So I would like to have clarification.
Very well, Senior Counsel. Maybe I'll read the whole program all the way to the end.
Thank you.
You will proceed. Of course, for the record, I will ask the National Assembly to officially rest their matter to allow you usher in your witness. Once your witness takes to the stand, you have 2 hours to present your case. The National Assembly has 1.5 hours for purposes of cross-examination. Thereafter, the senators will have 1 hour to seek clarifications or ask questions. Once that is done, the counsel for the National Assembly will have 1 hour to make closing remarks. Likewise, the team of the Deputy President will be given 1 hour to make its closing remarks. Once that is done, the Senate will move into a closed session as per our rules of procedure. So that is the program for this afternoon.
I'm now very clear, Mheshimiwa Speaker, and I thank you. The situation is now clear. But just before my colleagues on the other side close their case, can I, through Mheshimiwa Speaker, ask whether the National Assembly still wishes to call a witness whose affidavit was filed, the governor of the county government of Nairobi, Johnson Sakaja. We have a copy of his affidavit. Is he going to be called or not called? Because if the National Assembly is not calling that affidavit, whose affidavit is part of the record and was availed to us, that affidavit, Mheshimiwa Speaker, contains allegations that are extremely injurious to the Deputy President. So if he is not going to be called, we will be making an application for that affidavit to be expunged from the records of this Honorable Senate. Thank you.
Counsel for the National Assembly, you had listed quite a number of witnesses. Are you going to call all of them, or are you going to, for the record, are you going to close your case where we are now?
Mr. Speaker, sir, on behalf of the National Assembly, we shall close our case where we are. Mr. Speaker, sir, if you are with your permission, I could respond to the submissions by my learned senior, Mr. Paul Mwite.
Please do.
Mr. Speaker, sir, at the beginning of the proceedings that we are currently going through, this House did invite parties to give indications as to the witnesses they wanted to call. Mr. Speaker, sir, we gave the list of the witnesses whom we thought were relevant for purposes of clarifying what we needed to have clarified. If counsel for His Excellency the Deputy President did not do as much or did not take advantage of that window that was open, surely they cannot blame us for it. But secondly, and more importantly, Mr. Speaker, sir, yesterday, in the course of the deliberations in relation to one of the preliminary questions that had been raised, you gave a very clear ruling on the intendment of Rule 20 of the rules of this House. In particular, the understanding was that every material that was forwarded by the Speaker of the National Assembly to this House constituted evidence in support of the allegations that are the subject of inquiry by this House. It then follows that if the application that learned senior counsel, Mr. Paul Mwita, is making were to be looked at in its totality, he is actually making an application to amend or to remove certain aspects of the evidence from the record. Mr. Speaker, sir, that is an issue that you settled and rested yesterday. I don't think it's an issue that is open for re-intervention. Mr. Speaker, sir, it should also suffice to note that even on our side, there are affidavits that form part of the record that came from the National Assembly. In particular, there is an affidavit sworn and which is in favor of His Excellency the Deputy President, an affidavit sworn by the joint executors of the will, that is Mr. Njoroge Rigeru, together with the other executors. It is part of this record. We have not made an application to have it expand. We have an opportunity to deal with it when the time comes. Lastly, Mr. Speaker, sir, the nature of the sittings that this House currently is undertaking is quasi-judicial. It is inquisitorial in nature. If that is to be the correct position, Mr. Speaker, sir, then the rules of evidence as we know it in the court would not necessarily bind the proceedings, because what has been presented is the subject of what the honorable senators are going to investigate. At the end of it, it is not a judgment that they will be giving, it will be a vote. I rest my case, Mr. Speaker, sir.
Senior Counsel Paul Mwita.
Mheshimiwa Speaker, first and foremost, the affidavits that my colleague, my learned friend, referred to were sworn by the executors of the will of the late brother to the Deputy President. They were filed in the National Assembly, in the proceedings in the National Assemblies. They were never filed here as affidavits of witnesses that we proposed to call. With regard to the affidavit of Governor Sakaja Johnston, it was specifically filed in the Senate, an affidavit of a witness that they intended to call. That affidavit has material injurious to the Deputy President. Mheshimiwa Speaker, we were looking forward to cross-examining Governor Sakaja so as to bring out the truth to assist this Honorable Senate to make a decision. If he is not being called, then in fairness to the Deputy Governor, all that we are asking is that affidavit be expunged together with the affidavit of Peterson Jomo, who they are not calling now, and also the affidavit of Mercy Wajau, who is not being called. It is not fair to file affidavits containing information allegations injurious to the other party, then ask that those affidavits to remain as part of the record without calling them and availing them for cross-examination. So my application is that the 3 affidavits be struck out. Thank you.
Mr. Speaker, sir, just for clarity, there is absolutely no new material that was presented after the material that was sent to this House from the National Assembly. For instance, the affidavit by His Excellency Johnson Sakaja is to be found at volume 1 of the documents that have been filed.
Maybe Counsel for the National Assembly, let me get it clear.
Yes,
the
Mr.
affidavit by the Nairobi governor, was it filed after the proceedings of the National Assembly, or it forms part and parcel of the proceedings that came from the National Assembly?
It forms part and parcel of the proceedings that came from the National Assembly. In particular, Mr. Speaker, sir, all those affidavits form what constituted part of what came into through public participation.
So just so that we make progress. Senior counsel, you have indicated that the affidavit by the Honorable Governor for Nairobi did not form part of the documents that emanated from the National Assembly. Now, the position as held by the Council of the National Assembly is to the contrary. These are things we can settle now. Did it come with a bundle of documents from the National Assembly, or it was filed after the Senate was seized of those documents?
Mheshimiwa Speaker, I have been corrected by my colleagues. The affidavits where the affidavit by Governor Johnson Sakaja was actually part of the public participation. So it was part of the record of the National
So now,
yes,
let's
yes.
move to the two.
Yes.
Let's move to the two. Now, have a seat, Senior Counsel. Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Yeah, respond to the two more affidavits, because the contention from the Council of the Deputy President is that they were filed after the record was received from the National Assembly by the Senate.
Mr. Speaker, sir, I reiterate the position that we earlier on gave, that there's not any single document other than the document that was admitted yesterday pursuant to our application that came in after the record had been presented before this House.
So the affidavits were not filed after the Senate received the bundle of documents from the National Assembly?
Absolutely not.
Can you lead us to the volume and the page containing these affidavits from the National Assembly?
Mr. Speaker, sir, just give me 1 minute to consult with my colleagues here. I identify it, then I bring it. It's not an issue that we had anticipated.
Yeah, so that we settle this matter.
Most of that.
Yeah, let's settle it.
It is, Mheshimiwa Speaker, it's only the affidavit of Peterson Jomo that was filed in the Senate. It did not form any part
Very well,
of the
Senior
National
Counsel.
Assembly.
So then let's settle that one and we make progress. We need not argue on this matter.
Mr. Speaker, sir, I think what happened is that we skipped the opportunity to identify the documents from both sides of what had been filed. The documents that we filed yesterday has a volume 8. That is the document that contains the affidavit of Peterson Jomo.
So it is that affidavit, if you go to the Senior Counsel, it is that affidavit that they're looking forward to cross-examining the deponent. Now that you've closed your case, the argument from the Council of the Deputy President is, how then are we going to test the truth of those averments? What say you on that?
Mr. Speaker, sir, I did give an indication that, number one, at the commencement of these proceedings, any party who wanted to cross-examine any of the deponents of any of the documents had an opportunity, upon your invitation, to invite such parties to appear before them. If our counterparts appearing for His Excellency the Deputy President did not find it appropriate to call that witness at that point in time, they cannot now hold us to say that you had said you'd call this person, you will not call them. Because the person we were to call was for purposes of clarifying what we thought was important for us. Now, this being an inquisitorial proceeding, a quasi-judicial proceeding, Mr. Speaker, sir, I think it would be a stretch to expect that if we didn't call or if we didn't avail any of the witnesses that were mentioned in any of the affidavits, then as of necessity that follows that record or that affidavit needs to be expunged. That's what I was saying. Pursuant to your ruling yesterday, that is evidence and material that was presented yesterday. It forms part of your record.
Now, before I give my way forward, Senator for Nairobi City.
Honorable Speaker, the counsel that are appearing in this case are people that I hold in extremely high regard. Senior Counsel Paul Muite appears to not have the confidence of the judges sitting here that we know how to treat evidence contained in an affidavit that is not tested at cross-examination. Even the judges you appear before in the courts that you practice in know what to do with evidence of a person who is not availing themselves for cross-examination. So, Honorable Speaker, I really don't understand what the contention is, because we sitting here as judges know how to treat that evidence, and I wanted to take this opportunity to calm the anxiety of Senior Counsel Paul Mwite, that indeed we do know what to do with such evidence.
Now, so that we make progress, Senior Counsel has raised an important matter, which matter has been responded to by the Counsel for the National Assembly. Now, honorable senators, there is an affidavit sworn by one Jomo Mushira, who had been listed to appear as a witness for and on behalf of the National Assembly. The National Assembly has closed its case without calling that particular witness, and yet there's an affidavit that the counsel for the Deputy President will not have an opportunity to cross-examine. The question, as you retire at the end of this hearing, is to look at the probative value of that particular document. Senior Counsel Paul Mwite, your point is valid. The senators have noted.
Because this is an important, very important institution with a judicial function, court of record, permit me to put on record that there is a slight distinction between counsel and the client. I have absolute full faith in honorable senators, including my friend, the senator for Nairobi, but I am carrying out instructions of my client.
Yeah, so I've given direction on this particular matter. Let us move forward. Having said that, Senior Counsel Paul Mwite, if you're ready, you may now usher in your witness.
Mheshimiwa Speaker, we are anxiously waiting for the Deputy President. My colleagues can stand here, can stand in. For me, let me make inquiries and find out where he's held up. We certainly wish to call him as a witness.
Very well. Yes, what is the point of procedure, Senator Boni?
Unprecedented, to the extent that when we stand down business in this House, it normally arises from a communication from the chair that you're temporarily, for a specific time, suspending the proceedings. You have not done this, and we are seated in the chamber. The mess is in place. I do not know whether we want this to be the new standard, Mr. Speaker. Could you guide us? We have no idea how long we're going to wait. And time is running, Mr. Speaker.
Honorable Senators, at the rise of the House at 1:15, I made it clear that upon resumption, the Deputy President was going to take the stand. We came in here, I communicated the program for the afternoon, and I said we're going to execute it with military precision, owing to the fact that we need to conclude business today. Senior Counsel Paul Mwite indicated that he cannot get hold of his client. That is not the concern of this House. So time is running. Order, order, honorable senators, order. The floor is available to the Deputy President and no other senator or no other element.
Well, the Speaker of the Senate, Honorable Amason Kingi, currently presiding over the business of the Senate this afternoon, has just directed that the floor at this particular juncture is not available to any other senator owing to the...
Enoch, I used very basic English. I know you. You have such a wonderful grasp of the language. You need not to get any clarification.
It is exactly 15:04 p.m. this afternoon, being the 17th day of October 2024. The afternoon sitting of the Senate this afternoon was to kick off with the Deputy President taking the stand, bearing in mind the DP, His Excellency Rigathi Gachagua, is the sole witness in the case where the National Assembly, through the move of the motion, Honorable Mwengi Mutuse has leveled 11 grounds for impeachment of the Deputy President from office. We have already dispensed with the prosecution side, and during this afternoon sitting, immediately after the commencement of business, the council representing the National Assembly have confirmed to the House that they do not intend to call more witness in regards to this case. The counsel for the Deputy President had requested the House through the Speaker that any evidence where the witnesses are not appearing be expunged from the record. It is a moment of waiting at the Senate this afternoon as the House awaits the arrival of the Deputy President, Rigathi Gachagua, who is set to take this stand at the Senate this afternoon and prosecute his case through himself as well as his defense and convince senators why the 11 grounds listed for impeachment should be quashed by the House. Our dear viewers, the motion for the removal by impeachment of His Excellency Rigathi Gachagua, EGH, the Deputy President of the Republic of Kenya, has 11 grounds where the National Assembly is seeking to have the Senate uphold the charges, or at least one of them, to have the Deputy President cease to hold office today. The mover of this motion, Honorable Mwengi Mutuse, who also serves as Kibwezi West lawmaker, has told senators for the better part of yesterday and today that his desire through this motion is that the House finds the Deputy President to have committed the offenses listed in this motion. And this afternoon, the defense of the Deputy President, led by Senior Counsel Lawyer Paul Muite, will be seeking to water down those charges by the evidence that they will be presenting before the Senate this afternoon. And to just take you through probably some of the charges that the Deputy President will be seeking to counter this afternoon is charge number 1 on the gross violation of the Constitution and any other law. This is pursuant to Articles 150, subsection 1BI of the Constitution. Charge number 2 in the impeachment motion by Honorable Member for Kibwezi West. The Honorable Member alleges in his motion that there is gross violation of Articles 147, subsection 1 and 152, subsection 1 of the Constitution, where the Deputy President is being accused of undermining the presidency. Under Article 147, subsection 1 of the Constitution, the Deputy President is the principal assistant of the President and shall deputize the President in the execution of President's function. In this motion, the Honorable Deputy President is accused of going in contravention with cabinet resolutions on matters evacuation of people residing along Nairobi River, and that shortly after His Excellency, shortly after being in contravention with the cabinet resolution, the Deputy President made public a statement opposing the Nairobi River riparian execution orders. According to the mover of the motion, this is undermining the resolutions by the cabinet. Under charge number 3, again on gross violation of Article 6, subsection 2, Articles 10, subsection 2A, Article 174, and Article 188, and the 4th schedule of the Constitution, where the Deputy President is accused of undermining devolution. The mover of the motion in his motion states that on the 28th of September 2024, His Excellency Rigathi Gachagua, recklessly and mindful of the high calling and dignified status of the office of the Deputy President, unlawfully interfered with the running of the Nairobi County government by holding a public rally in which he incited citizens against lawful directives by the Nairobi City County government on the planning and relocation of markets. This is just some of the grounds listed or some of the annexes under charge number 3, where the Deputy President is set to defend himself on these charges, among others.
Senior Counsel Paul Mwita, your time started running.
Mheshimiwa Speaker, may I...
Let me just conclude, Senior. Your time started running at the time I requested you to usher in your witness. You indicated that you're getting hold of your witness. We'll give you all the time you need to get hold of your witness, but to let you know that the clock is running, and it's running on your client. You can take all the time, but his time is running out. After 2 hours, he's not appeared, the chair will make a ruling pursuant to the rules of procedure.
Mheshimiwa Speaker, may I start first and foremost by expressing apologies and regrets that the Deputy President is not here, and by not being here, the inconvenience and delay caused to Mheshimiwa Speaker and to honorable senators. The position, Mheshimiwa Speaker, is that during that period that I went to try to find out why he wasn't here, because as Mheshimiwa Speaker knows, the Deputy President has been coming here absolutely punctually every day. The sad reality is that the Deputy President, the Republic of Kenya, has been taken sick, very sick, and as I address Mr. Speaker in this honorable House, senators, he is in hospital, Mheshimiwa Speaker. That is a sad reality.
Order, honorable senators. Order, honorable senators. Senator Kajwang. Now, Counsel for the National Assembly, you have had Senior Counsel Paul Mwita for and on behalf of the Deputy President. Considering that this is a time-bound process. What is your reaction?
Mr. Speaker, sir, this is a house governed by the rule of law. We truly empathize with the difficulty that His Excellency, the Deputy President, has found himself in. But, Mr. Speaker, sir, pursuant to Rule 11 of the rules governing this process, if I may, with your permission,
maybe Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Just take a seat before you make your rejoinder. Senior Counsel Paul Mwite, having said whatever you've said, what is your proposed way forward so that a reaction can be put from the National Assembly? Are you telling us we wait until your client gets here? What is your proposed way forward?
Mheshimiwa Speaker, I have just received this information. My proposal is that you give me at least the rest of the day. I would like to go and have an assessment of his situation and maybe even come back here by 5 p.m. Right now, I would like to make an informed sort of situation after I see the Deputy President and I see the doctor, Mheshimiwa Speaker, at least an hour or two. Yes, thank you.
Very well. Counsel for the National Assembly.
Mr. Speaker, sir, having very keenly listened to my learned senior colleague, Paul Mwite, Senior Counsel, it puts us in a bit of a difficulty because whereas we may want to empathize with the situation, there appears to be no indication from their end as to a specific proposal. Mr. Speaker, sir, this being a house governed by rules and this process being a time-bound process, I will draw your attention to Rule 11 of the rules of this House. If I may read, Mr. Speaker, sir, that where the National Assembly or the President chooses not to appear before the Senate, that fact shall be put on record and the Senate shall proceed with its investigation without further reference to the National Assembly or the President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the President. Mr. Speaker, sir, I think this rule would give us guidance we may proceed. If it becomes necessary, then any additional material may then be availed. This is a time-bound constitutional process, Mr. Speaker, sir. I'm most obliged.
Let me pick the wisdom of my wonderful senators before I make my decision on the way forward. Now, I understand that all of you are wise men and women.
Speaker, can I just say a word?
Yes.
I've heard what Senior Counsel Paul Mwite has said. And, Mr. Speaker, you have made it quite clear that these proceedings are time-bound. It's not so much about the situation in which His Excellency the Vice President finds himself. It's about the Senate complying with the provisions of the Constitution. That within that time frame, you must make a decision. Reading the standing orders that my learned friend, Mr. Rick Gumbo, has referred to, it would be useful to this House if Senior Counsel Paul Mwite could probably give us a way forward in Yeah, in terms of the time limitation that the Senate has. I'm saying this because we don't want somebody to say that the Deputy President was not given an opportunity to be heard. I think the Senate will want him to be heard. But knowing the time limitation, what suggestions does the Senior Counsel have to ensure that we keep within the time parameters? At the same time, the Deputy President is given his space to defend himself.
So we have two sides. We have the minority side and the majority side. I will only allow the two leaders to speak. If you need to consult in the next 1 minute. Now, honorable senators, our standing orders have not been suspended yet. It is only Senator Mazayo and the majority leader. The rest, take your seat. The rest, please take your seat. Order, honorable senators.